3 News Now Web Extra.
Should that district court, which has jurisdiction only over things that either occur within the state or affect the state, be able to bind? In layman's terms,
Right.
what is it?
So at its simplest, is if the government wants to take something from us, and the Constitution uses the words life, liberty, and property, and life is easy enough in terms of, if it's a death penalty, et cetera. But liberty is if it wants to in some way restrict how we move about, put us in prison, in custody, send us outside the United States. So if the government wants to affect our liberty, it has to give us this phrase due process. And the two main components of that, or the two main pieces are, first, they have to tell us why they're doing it. It's called notice. Second is they have to give us an opportunity to respond to that. We shouldn't have to just take the government's word for it that they're right, that we committed a crime, that we're deportable, that we are an alien enemy. However, whatever reason they give us, they have to, first of all, tell us why they're doing what they're doing. And secondly, give us a chance to respond. And that is the essence of due process. It's notice and an opportunity to be heard.
And then why is that a key part of the Constitution?
Because otherwise the government has unlimited power. They could literally come to any of our homes, take us, and do whatever they want to us, imprison us, send us overseas. In fact, the president talked about his desire to imprison American citizens in El Salvador, that could happen literally at the whim of one individual who happens to be president of the United States, regardless of party. Without due process, it is unlimited, unreviewable power in one person.
And I assume that that's what the founders were reacting to when they were moving away from a monarchy, right? The power shouldn't be concentrated in the hands of one person or even just a few.
Yeah, so a couple of things that they did to make sure that we didn't fall back into a monarchy. One is that the president does have to be elected every 4 years. In addition to that, when the president is in office or any of the members of our government are in office, there are powers in the other branches of government to check that individual. So the president can be checked by impeachment, by Congress, and by the judiciary that can order the president to stop what they're doing if they're not giving someone due process.
Do non-citizens who are documented or undocumented also have a right to due process?
Absolutely. The Constitution says that due process is guaranteed to any person, not any citizen, to any person. And so regardless of your status, if you are in the United States, you have a right to due process. Now, how much process you get may differ depending on the context and the circumstance, but regardless of who you are, you should never have to be subject to the unreviewable whim of one government official. And it comes down to the specifics, because you're right. Once we get into the process that was given, there is a more nuanced, complicated question about exactly how much process a person is owed before they can be deprived of certain things. Imprisonment is, for a crime, is one of the most severe intrusions on someone's liberty, and so that will require much more process. We have a criminal process that gives all sorts of layers of guarantees. But short of that, there'll be arguments about how much process is appropriate, and process can be fairly streamlined at times. However, there has to be what the Supreme Court has referred to as meaningful, reasonable opportunity to be heard, and also notice. I mean, if a person does not speak English and they are solely given notice, and the government knows that, and they're solely given notice in a language they don't speak, and they have to respond within a short period of time, say hours, sure, that's a process, but it's a process calculated to fail and should not be due process. So the Alien Enemies Act that you mentioned, and it's interesting that you also mentioned the Alien and Sedition Act, is because they were passed almost at the same exact time in 1798 or in late 1700s. And everyone concedes that the Alien Sedition Act, which basically said you could be prosecuted if you criticize the government, clearly violates the First Amendment. Bad idea, shouldn't have been passed. Frankly, I think a lot of people feel the same way about the Alien Enemies Act. It provides no due process, but under situations where there is either a declared war, which we do not have, or where there is an invasion or a predatory incursion. That law has been invoked only 3 times in our history: the War of 1812, World War I, and World War II. In all 3 instances, a declared war by Congress, so it was never the unilateral act of one single person, the president. So this is unprecedented what's happening now. And it seems fairly clear from history that the other conditions, an invasion or predatory incursion, would be when there has been physical violence by another country on the soil of the United States. There's no claim that that has happened. The minute you get beyond those circumstances, what you have, and I think a lot of people, including myself, are worried about this, is that you have a president, regardless of party, who could invoke this simply because they want to take someone into custody without due process, and whether silence them or in some way take vengeance against them. And so this law could be, if broadly interpreted, could be an open invitation for the president, whoever is president, to target their enemies. I think people would all agree that if there is truly someone who is not entitled to be in the United States, then it is appropriate in a way that respects their dignity and does so safely, that they be removed from the United States. The big if is, are they really here illegally? Are they eligible for deportation? And that's why due process exists, so that we don't have to take that one person's word for it, and that a person has an opportunity to say, no, you're wrong, before something happens to them that may not be able to be reversed.
There is a related conversation happening right now, although it is a little bit separate, and it's about the power of the lower federal courts, I think the federal district courts, to whether or not they should be allowed to issue universal injunctions. And I know that the Judiciary Committee, and I know this may be getting in the weeds, I may be getting in the weeds here, which I do. But because Grassley's on the Judiciary Committee and he's made noises about limiting those lower federal courts' powers to issue injunctions, I'm just sort of curious. I'm sure you're following it. I mean, do they have an argument there?
Yeah, that actually is a very tricky one, and that argument's been around for a while. I mean, ironically, whether you're for or against national injunctions seems to depend on whether your party's in power or not. And this is both sides. I'm not criticizing one side or the other, because Democrats were aggrieved when there were national injunctions against nationwide injunctions against things Biden had done, and now the Trump administration is aggrieved when they do it against him. I think there are good and important arguments that a district court in one location, let's take, for example, there's a district court in the state of Nebraska. Should that district court, which has jurisdiction only over things that either occur within the state or affect the state, be able to bind all the other districts around the country? I think there's a strong argument that that shouldn't be the case. The U.S. Supreme Court's never decided it, actually may get to it in the next couple of months. I believe the case that's on the docket that they have special argument on May 15th may raise that. And that is a serious question that is an open one and predates the most recent controversies. This has been something people have been concerned about for at least a couple of decades, regardless of party and regardless of who is in the Oval Office.
I think, whoever is discussing that too, I'm guessing they have to take into consideration, am I comfortable with this if I'm not the party in power?
You think they would. There's an awful lot. I mean, actually, one of the things that it seems obvious that in our government that thought process has been important is the filibuster, because it has been within the power of a majority of the Senate to do away with the filibuster. And regardless of who's been in control of the Senate, that institutional safeguard has been kept in place, and it doesn't have to be. Now, when it comes to injunctions, I think one of the problems is it's not just the institutional actors, meaning like someone who's in the executive branch or Congress who's controlling what lawsuits are brought. So it's always in the interest of some litigant, a public, some sort of public organization or nonprofit, to get the most relief they can. So I get that. I mean, it's not going to be those litigants are not going to necessarily have the institutional interests in mind the way someone who is in a government position would be. And when their lawyers are advocating for them, the lawyers have to make the strongest arguments they can to be the most zealous advocates they could be. So as long as national injunctions are on the table, I actually think it's a lawyer's responsibility to ask for it as relief for their client.